Okay, this is People of the State of Michigan versus Kaviris Brown, docket number 20-684FH. And this is the time set for sentencing. Mr. Brown, can you just confirm for me that you are okay with doing the sentencing remotely instead of in person?
Yes, Your Honor.
Thank you. You were convicted of possession of ammunition by a felon and also carrying a concealed weapon, and the prosecutor's proceeding against you as a habitual second offender. So both of those are felonies, and because of the habitual second, both are punishable by up to 7.5 years in prison. You have the right to an attorney, and you are represented by Mr. Zaney. And Mr. Zaney, have you had a chance to go through the pre-sentence report with your client?
We have, Your Honor.
Do you have any additions, deletions, or corrections?
Yes, Your Honor. If I could point the court's attention to the face page of the report, top right indicating appointed or retained. It says I'm appointed. I'm in fact retained.
Yep, I fixed that.
And I think that also appears in the body of the evaluation and plan, page 1. Is it me? I think the report I have doesn't have page number, so I apologize. I think it's page 1.
No, it seems like none of them have page numbers anymore. It's difficult.
Judge Collette taught me that 10 years ago to make sure I put page numbers on, or else he would yell at me. So I try to.
I'm sure he did.
He did. Yes, Your Honor, he did. Now I'm telling you, remind me this. I digress. Back to the face page of the report, prior record, convictions, felony. Based on what was provided, Your Honor, I calculated 3 prior felonies. And I used that.
Okay, let me just count them.
Yes.
1, 2. 3. You're right. The people agree?
The only thing, Your Honor, it says final, so I think we're all looking at the same one, 13 of 15. It says final charges, possession of a weapon by a felon, and then unlawful imprisonment. But if you look at the sentence or disposition, it says he got 24 months for the felony firearm. So I'm wondering if they just forgot to count that as a conviction, but it's.
Oh, yes. Yeah, I see what you mean.
Okay.
So, Mr. Zaney, is it possible, since they did put the felony firearm sentence in there, that he actually had 3 out of that incident?
If I may, just 1 second, Your Honor.
Sure.
Your Honor, we'll waive that objection, find it to be accurate. Thank you, Mrs. Allen, for that information. So that won't need to be corrected in the body of the report, because I think I was wrong.
Okay. Okay.
And then we do, though, just going to confirm, Your Honor. I'd ask the court, and I think you'll see a little bit more of this, as far as the agent's description of the offense. Not sure how we should word it. This comes into our arguments on the OVs as well, so the court's aware. We just asked that it be noted that Mr. Brown indicates he was not involved in the conduct described by Frederick Wallace.
Where it says KJ got out of a white Cadillac and produced a revolver. He pointed the revolver at him.
Correct, Your Honor.
Well, that's the agent's description of the offense. So I don't think I'm going to change it. And in the defendant's description, of course, it doesn't make mention of that. I can add defendant denies this after it says what I just read.
Thank you, and I believe that'll meet our intents. Thank you.
All right, so I just added defendant denies having done this. Okay, did you have more, Mr. Zaney?
No further additions, corrections, or deletions to the body of the report. We do, I believe, have a stipulation relating to guidelines.
Oh, okay, then tell me what that is, or unless you want Ms. Allen to do it.
Sure, she hasn't said much. I feel like I'm talking too much.
You get to go first. That's how it works.
Oh, okay. I think we agreed OV 1 should be scored at 0. I just want to confirm that also included. Did that also include OV 12?
Yes.
Yeah, so OV 1 and OV 12 would be scored at 0. It'd make the offense level OV's 0 guidelines of 9 to 28.
And that's correct.
So
Your- We received a phone call from the victim regarding this incident that we've turned over to defense counsel denying the assault that took place, which is, I think, where Mr. Zaney was going with his initial comments too. So we've agreed to not score those based on the conversation and the evidence we've received.
Okay, let's back up then, because I want to go back to the PSI. And I'm going to add, after I put defendant denies having done this, I'm going to say, and Mr. Wallace has recanted. Is that fair enough?
That's appropriate, yes.
Okay, now back to the guidelines. So he's a F1, is that correct?
Yes, Your Honor.
Correct, Your
And
Honor.
you said that's 9 to 28.
Yes.
Yes, Your Honor.
Okay, got it. And did the people have any other corrections or objections?
No, Your Honor.
And did the people wish to be heard?
Yes, Your Honor. When I was reading through this report and looking at this defendant's criminal history, and the writer notes that within 7 months of being off of parole for felon in possession of a firearm, we're here again with firearm offenses, possession of ammunition and carrying a concealed weapon. And while I think Swift and Sure is a great program, I also believe in this case that a period of jail time has to be appropriate as well, just to give him only probation after here again on his 4th felony offense, again, a gun crime, again, after he's been off parole. I understand I'm not asking for prison. We dismissed the felony firearm and that's, the guaranteed 2 years if we wanted to do that. But I still don't think that means he only gets probation. I think a period of jail to emphasize that regardless of what happened with the victim on that day, which he's regained, we still have the situation where he's again involved in something that there's a traffic stop and that there's not. So we would ask, I think a jail period is more than appropriate and necessary. Thank you.
Thank you. Mr. Zaney.
I would just say, Your Honor, appropriate is not always necessary. I think that there's a distinction in this case. I think I was in litigation and I remember someone standing up to the federal judge saying, Your Honor, don't let perfection be the enemy of progress. I thought, heard a more potent statement in my eyes. We rarely see perfection. Do we ever see perfection, frankly? In this case, the lack of perfection is going to create the progress. One thing that's been noted for Mr. Brown is he does well when he's supervised. Supervision is appropriate. By no means is this a slap on the wrist. If the court does provide Swift and Sure, we understand the success rate and the difficulty in completing that program. It speaks for itself. The end product, I think, is going to be as near to perfection as we can expect. And that's simply progress. Now, though it may seem appropriate for jail, I'm not sure if it's necessary. Looking at what we have going on in the jail, looking at what we have going on in the community, I find it to be difficult to say that's necessary. He has some progress. He does have children he takes care of. He's an active father, not just a father. He is someone who sees his kids on a daily basis, but he's taking the initiative to get himself employed. He's taking the initiative to start down that path of hopefully and inevitably the full reformation that we seek. I think as part of the sentencing factor towards punishment, it's appropriate to note, again, the nature of what we're doing is not a mere slap on the wrist. The nature of the recommendation, I apologize, is not a mere slap on the wrist. That if the court were to impose jail, ask that it be suspended. Suspended, and let's see how he does. See where these things go. I would ask that though we strive for perfection, we consider the progress. And in this case, he has that progress. And I think the support of those around him.
All right, thank you. And Mr. Brown, was there anything that you wanted to say?
Yes, Your Honor. Give me a second.
And Your Honor, he does have his phone. He's reading it off there is where he took notes, if that's okay.
Sure.
Your Honor, over the time I've been waiting to come back to court, I've also had plenty of time to think about my life and what's been taking place in my life. After losing two of my children's mother in the same year, my life hasn't always been the best, but it's life. I've also taken time to realize that it's time for me to be more of a father to my children and less of a nuisance to society. I'm aware of my actions, and I know that actions speak louder than words, and there's a reason why I'm putting my best foot forward towards reaching my goals and achieving them without taking alternative methods that would land me right back here in front of you. Your Honor, this is it for me. My children's mothers are gone. They're never coming back, and all I can do is be here for them and be a productive citizen if I'm given the chance. It's a lot more I wrote and it's a lot more I could say, but that's just from my perspective, and I'm asking for the opportunity to make it right.
Well, you've made this difficult, Mr. Brown, because everything the prosecutor said is completely valid. And I would not be wrong if I did exactly what she suggested. You've also said some insightful things yourself, and the recommendation here is for swift and sure sanctions, which is it is swift and it is sure. If you mess up, you have a sanction and it will happen, and Judge Kennedy will deal with you on it, and it's something that you can count on if you don't follow the conditions of probation. And then added to that is that it is a time when I try to avoid sending people to jail if it's not absolutely necessary, such as for a violent offense, an assaultive offense. That's where we're reserving our jail beds these days. It's easy to argue that you don't deserve another chance given the circumstances here.
I agree.
I'm just a big believer in second and even third chances when people really want to do better. You have to do more than just say the words, though. You can't just talk the talk, you got to walk the walk. You really want to be a good father, then stop engaging in this nonsense. This is serious stuff that lands you in the Department of Corrections. So, you want to be a good father, you be there for your kids, and that means stop running around with weapons, stop engaging with people that you're, having disputes with, stop running around on the streets when, you have it in you to be a good dad, and you need to step up and do it.
Yes, ma'am.
There's, again, every reason in the world why I should be sending you to jail. But I'm going to let Judge Kennedy deal with you. And I'm doing that not in the sense that I think you're going to fail and he'll nail you for it. I'm doing it in the sense that when you tell me you want to do better, I'm going to hand your fate over to you and you alone and say, show us. And if you don't, your fate is in your hands and you will be dealt with accordingly. And if you do step up and like you say you want to, then it's win-win for everybody. Then, you know, you've become a better functioning member of society. You've become a better dad for your kids, and you won't be in front of a judge again, and you won't be going to jail. That everybody benefits from that. So I want to give you the chance to do that. I'm going to place you on probation for a period of 18 months. I'm not going to do a suspended sentence only because I am sending you to Swift Insure Sanctions, and they have their own set of sanctions for different kinds of violations, and I will leave it to them. So I'll say 2 days in jail with credit for 2 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs. Cost to the county in the amount of $250, which is a large reduction from the State Court Administrative Office calculated average cost for a criminal case in Ingham County. I'm waiving supervision fees. Conditions of probation are no use or possession of alcoholic beverages, controlled substances, drug paraphernalia, or medical marijuana. Comply with both drug and alcohol testing as your agent directs. You must complete a substance abuse assessment if you are referred for that. Complete outpatient or residential substance abuse treatment. Complete the MRT program. Waive confidentiality and allow any program you're in to disclose information about you to your agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You may not possess a weapon while you're on probation. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant and report any changes to your agent within 24 hours. And you must participate in and I hope successfully complete the Swift Insure Sanctions Probation Program. Mr. Brown, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It will explain that more on a form that we will send to you called Appellate Rights. You will need to contact the probation department within 24 hours to set up your probation. In other words, to have them go over the conditions with you, talk about what you have to do now for Swift Insure and how you will get into that program, and etc. So do you have any questions?
Except where to get the number from, Your Honor.
Mr. Zaney, can you give him the number for adult probation?
I can, Your Honor. And do you want me to provide him the notice of appellate review? I do have it available in the.
You have it?
I can grab it off the printer and serve him on the record if you'd like, or
That would be great. I'd like to be able to say for the record that he's got it.
just 1 second, Your Honor. Thank you.
Sure.